It's on.
Yep. Good evening, folks. This is Del Steady Merced. Today is Tuesday, January 28, 2020. Welcome. This webinar is being recorded. This evening, in addition to Lynn Beekman, I am joined by two of your colleagues, and perhaps a third will be joining us soon. I am joined now by Nancy Liederman and Israel Warman. Thank you both for participating in tonight's webinar.
Pleasure to be here.
You're welcome.
As always, I must review some important information. I'm going to get up and start playing the PowerPoint deck. You should be able to see that now. You should be able to see the title page on your screen. So a couple of items that we have to review as always. The first is that an affirmation form was sent to you in the email that I provided the training outline in. If you cannot find it, you can download it using the control panel on your screen. Today's documents that I will be relying on are uploaded to the control panel. Just click on the document that you need and it will automatically start the download onto your computer. There is a document 3, developing the hearing record. I will not be citing to that document specifically during our discussion. However, there is a footnote, I think it's footnote 53 in the ethics outline that refers to it, and I wanted to make sure you had it just in case. You have seen this document in the past. We've used it in a prior training program.
It's 54.
Oh, it's 54, footnote 54. Thank you. At various times throughout the webinar, there will be various codes displayed on the screen. These codes can be numbers, they can be a combination of words or a combination of numbers and words. You must write down these codes on the affirmation form that was provided to you. I will not be reading the codes out loud, so in part because you're required to view the program, not just listen to the program. So I repeat, I'm not going to be reading the codes out loud. So if you're going to be stepping away from the computer, you're going to hear me say the code is up there. At that point, you better get back to your screen before we go on to the next slide. Should you have any questions during the well, one second. I didn't give you let me give you this before you guys jump on me. Give you plenty of time. There it is. Let me put that course code up. So the course code is displayed on the screen right now. Write that course code number on the affirmation form. Please write that course code on the affirmation form. I'm going to leave it up during the remainder of my opening remarks. So make sure you write this down. Submission of this affirmation form is necessary both by the New York State CLE Board as well as the New York State Education Department for continued certification as a hearing officer. Please keep in mind that only hearing officers who participate in the entire webinar session will meet the training requirement and are eligible for CLE units. CLE credit will not be awarded and the training team cannot attest to your participation unless the codes submitted on the affirmation form are correct and you viewed the live program for the full 2 hours. Partial participation will not be accepted and NYSED will require you to view any aspects of the program that you missed. GoToWebinar tracks the time a participant signed on and off during the program. I must receive the affirmation form by next week, Tuesday, February 4th. Again, next week, February 4th, Tuesday, February 4th, I have to have that affirmation form. That date, by the way, is also listed on the affirmation form. If I don't receive your form by that date, you will not be considered for CLE credit, and NYSED will be informed that you have not met the training requirement. You, as you know, are all muted during the presentation of the program. However, we will attempt to answer as many questions as time permits. We will also accept as many comments as time permits. As you know from the last 8 years, there is a dialog box on your control panel that allows you to send questions in. Lynn will be moderating today as I'm doing the presentation, so he will receive the questions during the course of the presentation. We will stop to entertain as many questions and comments as time permits. Finally, as I indicated in my email providing you with the documents for today's presentation, at the end of this session, there's going to be a dialog box that comes on once I close out the program, and that is going to be the feedback form, the evaluation form that comes directly to me, and we review to get your thoughts on the program. So please take a minute after the program ends to fill it in. It doesn't take longer than a minute to fill out. So please take a minute after the program ends and fill that out, and it would be helpful to us. So with that, let's begin. So that course code is going to go away. Write it down, last chance. 3, 2, 1, gone. Let's start with a hypothetical. Nancy, Israel, listen closely because I'm going to be asking you. An inmate sued prison administrators and staff because he was not provided with his Santac for his reflux as prescribed during the times of day that he's required to take it. Rather than providing the Santac with his meals, it was given to him hours after the meals, and he alleged that he suffered severe pain and discomfort. The district court granted summary judgment in favor of the prison officials. The inmate lost. The inmate appealed to the circuit court. The circuit court reverses the lower court, the district court, citing in part to multiple websites, including Wikipedia, the Mayo Clinic, and the Santac manufacturer's website, to illustrate that there were genuine issues of material facts that went unresolved in the lower court, and that summary judgment was not appropriate. Neither the specific references to the website nor the information included therein were part of the record below, were part of the record in the district court proceeding. So,
Would you like a reaction?
not yet, I don't.
I'm waiting for a question, yeah.
I don't want your reaction just yet. I'm gonna get their reaction first, so give me 1 second. All right. Are you
Now?
seeing the poll?
Yeah, it was there and then it went away.
Uh-oh, what happened? Oh, all right, whatever. We're gonna have to try the next one with it. I may have closed it too quickly. Oh well. So you two, I like your reaction. Was it proper for the circuit court to rely on Wikipedia, the Mayo Clinic, and the Santac manufacturer's website to decide the case?
Well, did they send, it's an appeals court, didn't they just send it back to the district court?
Well, they
'Cause
reversed the
that would
district
make
court.
a difference. Yes, but that would make a difference, wouldn't it? If they sent it back to the district court and to further, look at the facts.
Well, so presumably, what would have happened, right, is what would have happened is that they would have reversed the lower court on the summary judgment, and it would go back to the district court for trial.
Right,
Right?
exactly.
Yeah.
Yeah.
So you're saying no harm, no foul, right?
Well, basically, yeah, because in fact, they're not making a determination on the facts. They're just making a determination about the summary judgment.
I'd like to give a different reaction to this.
Yeah, give me one second,
Sure.
Israel. Michael, are you there? Can you hear us?
I'm here. I am here.
Good, thank you, Michael. Michael Lazan, everybody. So Michael, you can mute yourself when you're not reacting, but you're now on with us, and thank you for joining us. Okay, so Israel, sorry for interrupting you.
Sure. I think it was appropriate, but in my view, the court should have taken judicial notice to give the parties an opportunity to react before, and it should have been made a part of the record. And by the way, I'm looking at a book which deals with this. Richard Posner, the famous Seventh Circuit judge, he has a book called Reflections on Judging, where he defends internet research by judges and says it's become easier. Judges and law clerks are doing more of it, that is internet research. It has given rise to controversy. And he specifically says the web is an incredible compendium of data, a potentially invaluable resource for lawyers and judges that is underutilized by them. But then going on, he particularly talks about the controversy it causes, and he particularly raises the problem about Wikipedia, which is known to be unreliable. So, and he also says that the lawyers should do more of it, and the judges wouldn't have to do it.
You know, it's Israel's going ahead of the line. He did some homework, folks. So let's see, Michael, do you have a reaction? Can you top Israel's extracurricular homework here?
I don't think so. I don't think I can top Judge Posner. He's Seventh Circuit. I think I'll jump in on the next.
He stepped out.
If I could say something though, I mean, I agree with Israel that the parties deserve a time to discuss the facts, to argue the facts in this case. My answer was just based on the fact that I assumed they would have the opportunity to do that back at the district court. Right. Certainly once you go outside what the record is, right, then in fact the parties should be allowed to come in and discuss that.
So it's interesting. I think I wrote to you guys on Friday. All three of you said, it's ethics. There's no right or wrong answer, right? So you both have valid points, right? And as Israel points out, Judge Posner of the Seventh Circuit found it proper. It was his opinion. In defending his independent research, Judge Posner explained that the record alone provided sufficient basis for the reversal. So Judge Posner, in his defense, says, hey, wait, I didn't go out of my way here. The record alone, if I didn't even look at these three websites, the record alone would have been sufficient for my decision, or for the majority's decision, right? Because there were there was another judge in the majority decision. There was a panel of three. He also says that the internet research served simply to, quote, underscore the existence of a genuine issue of material facts. This is just corroboration. In his mind, it would have been a miscarriage of justice not to have sought the information out and to have decided the case on what he calls an underdeveloped record. The inmate did not have the expert medical testimony that he required to support his claim and his case. And this disparity in resources between the inmate and the prison officials just did not sit well with him and the other judge that sided with the inmate. The dissent, however, we have a little bit of both here, right? We have a little bit for Israel and we have a little bit for Nancy here. The dissent took issue with Posner's reliance on what he felt were questionable sources and disregard for Federal Rule of Evidence 201, which is the rule that governs judicial notice. He was further bothered by the practical implications of judges, especially at the appellate level, supplementing the record in the manner that Judge Posner did, effectively resulting in the record never being closed. So to Judge Posner, he felt that if we as appellate judges do this, then the record below would never be closed because we essentially can expand, supplement the record by our own independent research. Lynn, before I move on to the next, I see that there are a couple of questions, maybe reactions. I don't know whether they're reactions to the question I posed and whether you want to share those at this point.
I don't see any on my questions.
Oh, okay. So if you just give me a second. And it's a question that is it really appropriate for an appellate court to take judicial notice of what's on the web? Implicitly, yes. At least that's the answer from one of your colleagues. I don't see any others on this, so I just wanted to share that before I move on to the next slide.
Danny, can I just add something?
Yep.
I actually did something like this a number of years ago, where I took notice of something on the DOE's website because there was a dispute about what is the nature of a particular DOE program. I did inform the parties that I would take judicial notice, give them a chance to react and see if they object. The DOE actually objected. I overruled it and put it in. It became part of the appeal, and the SRO ruled that what I did was appropriate. And actually, I use it much the same way as the example you just gave, because the SRO noted that it was only additional support for what I already concluded from what came forward in the hearing, and this just gave additional support that is in fact what the program is like. So they said, SRO said it was appropriate.
Oh,
But
Can I do?
Israel,
Can I add?
I'm
Can
sorry.
I
go
add
ahead.
something?
yeah, Michael.
I personally think it would be unwise for hearing officers to cite to the internet. Judge Posner is a famous judge. He was considered for the Supreme Court as an international scholar. He can get away with a lot more than we can. And I think that you're asking to be reversed if you start doing that. You might be able to get away with it, but I sure wouldn't try it. That's my opinion.
I wouldn't do it every day.
Can I make a comment on what
Yeah,
Israel just said and what Michael said?
Yeah,
which is
one
that
second, Nancy,
what-
1 second. I just want to point out that, Michael, you're underselling yourself. Just this week, you were cited on Special Ed Connection. So I'm just saying, go ahead, Nancy.
There's the
Can I
award.
footnote that?
Okay, so, all right, so what Israel described was putting something on the record. What Posner described was not on the record. The record is basically testimony under oath and documents on the record. But I just want to also endorse what Michael just said, in that it really comes under the category of no good deed goes unpunished, which is that if you're going to snoop, there may be consequences, right? And those are consequences you're going to have to live with as a judge.
Right. When I get calls from hearing officers and there's no clear answer, it always comes down to what you said, Nancy, which is, well, how far do you want to stick your neck out? Sometimes, you can do so and no one's going to slap you, and other times they do, and that's just part of being a judge, right? I did get another comment that simply says research can be appropriate when vetted websites are used. We're going to talk about that a little bit more in terms of, okay, yeah, it's vetted by whom? And I think this is what you're all saying is there may be circumstances when it's appropriate, And there may be and how you go about it may allow it to be appropriate, and there may be circumstances when it's not appropriate. So kind of let's talk about that a little bit, and let's move on to the next slide, which is today's topic of discussion: to Google or not to Google. We live in a world, as you know, where email seems dead, or at least maybe folks younger than us, our kids, email seems dead, replaced by text messages, Facebook chats, and whatever else fulfills our need for instant gratification. You have a question, no need to risk a paper cut using Encyclopedia Britannica when Alexa and Siri are just a shout away. And I'm looking, oh, my Alexa's back there. She might be responding in the background. Books have been replaced by tablets, iPads, Galaxy, Surfaces. Libraries are arguably obsolete, occupying, and I'm not going to say that too loudly because my youngest is a big library buff, and so is my wife. But they, for the most part, are occupying prime real estate in the world where public funding, in a world where public funding is shrinking and not being sent towards public libraries. And best of all, onerous trips to the law library. Remember those days when you had to run to the law library to get your research? No longer. A few taps of the key, moving the mouse around, and voila, you have a lot of information at your fingertips. This easy access to limitless information has judges, scholars, and more humble folks like us asking the question, what is permissible internet research for today's judge? And Israel provided an example. Judge Posner, what did you say, a book? He wrote a book on it. So clearly it's at the forefront of the judiciary. So we're going to look at some of the ethical considerations in this space for the next few minutes. And then towards the end of the at least primary presentation, we're going to work through some hypotheticals to try to flesh this out a little bit more. Now, it might come as a surprise to you that judges with some level of frequency use Google and other search browsers to get answers to difficult issues that are before them, or to confirm or discredit arguments that are made during trials, and to validate their analysis. And they do so openly, citing to their research and their decisions. In the two legal articles that I cite to in the ethics outline, there is empirical studies that have been done to support the prevalence of judges doing this independent research. This growing phenomenon, along with the growth in the use of smartphones, tablets, and the like, is the likely reason why the American Bar Association Standing Committee on Ethics and Professional Responsibility issued an advisory opinion in December of 2018, if I'm remember correctly. They call it a formal opinion on the subject of internet research by judges and when such research is permissible and when it is not. The legal framework that is used in this formal opinion by the ABA is instructive and adaptable to IDEA hearing officers. As a general matter, the technical rules of evidence, as you know, do not apply in administrative hearings unless the enabling statute specifies otherwise. IDEA does not prescribe a specific set of legal procedures, including evidentiary standards. What IDEA does is that they send it back to the states and says that the states can apply state evidentiary standards if they like, such as whether the testimony is relevant, reliable, and based on sufficient facts and data. And if you look at the New York State statute, if you look at the regulations of the commissioner, there isn't a specific reference to the federal rules of evidence or the New York State rules of evidence or the civil rules of procedure in New York. They do throw in some of that language about evidence has to be relevant, it can't be unduly repetitious, it has to be reliable, and one other requirement that I can't remember at this point. Nonetheless, the hearing officer under IDA is required to possess the knowledge and ability to conduct hearings in accordance with appropriate standard legal practice. And this requirement is sufficient to ensure that our hearings follow proper legal procedures, including the use of evidentiary rules, albeit so with some wider latitude than what is permissible in courts. And when we were chatting before we got started, I talked about hearsay, right? Hearsay is permissible. What's relevant is the number one question we ask ourselves when someone is seeking to introduce the testimony of a witness or introduce a documentary or a document for our consideration. It also follows that, like the courts, our due process hearing system must be independent, fair, and impartial. And I suspect that many of you jealously guard your independence. It would be expected, therefore, that our cases are decided based on only the evidence that is presented at the hearing and available to the parties. That's what's expected. That's what's expected of the parties that come before you. That's what's expected by the attorneys that comes before you. And certainly that would be what's expected by even pro se parents and pro se litigants that come in the school district side, particularly in New York City, because that practice doesn't extend to the rest of the state. But that's what's expected, that you're going to rely on the four corners of the record that is in front of you. Anything less would undermine the impartiality of the system, will undermine the impartiality of you as a hearing officer, compromises the integrity of the process, and erodes public confidence in the hearing system. Fairness dictates that each party is therefore afforded the opportunity to present evidence to a neutral decision maker, you. Independent research of facts, unauthorized contacts with the judge serves to undermine the process. And we know that ex parte communication, even though there's no regulation in New York State and the commissioner and the regulations of the commissioner or the education law, there's no regulation about ex parte communication in there, but there is, it is expected of you that there would not be any ex parte communication with you except in limited circumstances. Three that come to mind is scheduling, right? Traditionally, scheduling is permitted, and I suspect that despite the allowance of being able to speak to a party individually, one-on-one for scheduling purposes, that most of you avoid it like the plague, right? Because you don't want any appearance of an ex parte communication. You don't want anyone to accuse you of going beyond the scheduling, and if the other party is not privy to the discussion, they can wrongly believe that more happened than just scheduling. The other two would be administrative and emergency purposes. Something happened on the way to the hearing. The attorney calls you and said, I just got into a car accident. I'm sorry, I can't get there on time, right? Those exceptions are permissible under the ex parte rules. What's an ex parte communication? It includes any communication between a judge and a party or his or her representative concerning a pending or impending matter that is outside the presence, awareness of the party, the other party, and or his or her representative or attorney. But It also extends to other communications. That's kind of weasel words there, right? Other communications. What does that mean? Made to the hearing officer outside the presence awareness of the parties or their representatives. And like the judge, we too, as hearing officers, should not initiate, permit, or consider any ex parte communications of any kind.
Steady?
Yeah.
I'd like to ask the panel, to what extent, if at all, do you adhere to the ground rules that Steady just reviewed? Are you at all willing to take risk, even if the party said you could talk to the other party or about something that normally would be ex parte? And have you done something, got your hands slapped? What's been your experience with regard to these ex parte communications?
Well, I prefer using email. One reason for that is it allows you immediately to be talking, communicating with both parties at the same time. But certainly for scheduling, there sometimes you have somebody in front of you, the other person's not there, and you can. I've asked people about their calendar, and then I immediately go to the other side. I'm well aware of that scheduling exception, and it just makes it much more practical sometimes. But in general, I try to have everybody at the same time. But it does happen with scheduling, and I don't lose sleep over that. I understand that that's really not a problem.
I've had ex parte communications often on minor matters where I've talked to one party, then the other party, and assured them that I would get back to the first one if there was any change. But this is really, as you say, on administrative type things. As far as scheduling goes, I think I don't know if I'm alone in this, but I basically do my scheduling without talking to the parties. I just notify them via email what the scheduling is, and if they need an adjournment, if that's not a problem, they can get back to me on that. So that's not a problem, or at least not a problem for me.
A couple of comments or questions that came through while we were talking. I don't think they're looking for an answer per se. Is there a difference if you look at Wikipedia or look at the Mayo Clinic? I guess it depends on how you look at it, right? At least the Mayo Clinic is going to suggest that their information, to borrow the word earlier, is vetted versus what Wikipedia and how Wikipedia works, which is if it's vetted by many individuals. Anyone can contribute to WikiLeaks and can modify and submit information. Another IHO says, interestingly, my kid's middle school does not allow citations to Wikipedia. Yet Judge Posner did it, right? You might want to send your kid with Judge Posner's book on Wikipedia.
I just want to say I've actually given money to, I think other people have as well. I've given money to Wikipedia when they've asked for it. You know, they ask for $dollars every so often.
Yep. When you go right on. By the way, they do a fantastic job in getting the high profile on Google, right? If you look up any information, one of the first websites that come up is Wikipedia. So they do some, what do they call that? SEO, whatever it is, the ranking, so that you could get up there, or maybe they just pay to be one of the first. The pharmaceutical company's website is vetted because it must conform to FDA regulations. Wikipedia is not vetted. So again, this is the same hearing officer who initially says, hey, and I may be reading into this, but the hearing officer seems to suggest that it's permissible if it's a vetted website versus a non-vetted. The question is, what does that mean, vetted? And how do you know it's vetted? The manufacturer's company's website is also a marketing tool. To what extent, and I don't know the answer to this, to what extent does the FDA really police what is documented on the website? To what extent, for example, does the CLE board police your own website as an attorney, right? Where there are legal ethical requirements that says that you're supposed to say that this is advertisement, or that you're not guaranteeing this language that you're supposed to put. Do they go out, or is there someone who's plugging away at different websites to make sure that you're complying with the ethics rules? I don't know if that, and if there is, I don't know how far that extends to, for example, the FDA looking at the Santac website. Any comments about hearing on record when one party fails? Any comments about hearing on record when one party fails to appear? If I'm understanding the question correctly, you have a failure of a party to appear, but you go on the record and you engage the other party who did appear for purposes of deciding perhaps a path forward, purposes of rescheduling. Any of you panelists, esteemed panel, want to take a stab at that as to whether you believe that is proper? Would you do it?
To go on the record with one side there,
Yep,
and the other side not there. Well, yep. It can be, sure, because if one side doesn't appear, then you have, I think, the option as a judge or a hearing officer to go on the record. If they're late, they don't show up. It's a judgment call whether you want to do that or not. But I think you can, and it's not really an ex parte communication, isn't it? Because there's a transcript. It's not quite the same sort of ex parte communication as two people talking in a room. So I think it's
Michael, Michael, how might you mitigate against the ex parte concern?
Well, I would let's say it never happens, but let's say a party doesn't show up to a case. Well, I would probably send that party an email asking them to appear, or a phone call asking them to appear, and giving them a fair amount of time to appear, and warning them that I would be going on the record if they don't respond. And then if they don't respond after a fair amount of time, I think it's fair to go on the record.
Right.
Well, and beyond going on the record, I mean, it depends if you're talking about a pre-hearing conference or a hearing. But at a hearing, when a party hasn't appeared, when it's been the district, I've not always, but I have on occasion defaulted them because they haven't appeared. All right. When it comes to a pre-hearing conference, I'm more
lenient.
Thank you for the word. Yes, I'm more lenient about that because I realize that everybody is super overscheduled when it comes to pre-hearing conferences.
Regarding pendency, I've had pendency hearings which I believe are unopposed. You never know for sure till they get there, and one of the parties doesn't participate, and you can't even reach them. So we go on the record. Then what I've done is I send an email to the party that didn't show up, generally the Department of Education, and say, here's what happened. They asked, by the way, when I get to the documents, I say that I just list them subject to objection from the other side. I've done this many times. I send an email to the person that didn't show up. You object to these documents going in or dependency, and I describe it. And I think just about every case where that happens, I get an email back, no objection to either one. So we didn't have to hold up dependency, and they were informed. And had a chance to object. If they did, I'd call them back.
So just some nuggets from everything that everyone said, right? There, at least I hear an attempt to try to mitigate at least the concern of that there was an ex parte communication, and perhaps you may have no choice but to move forward on the record, right? You all said I would do it on the record, right? And by that, there's a recording of it is how I am defining on the record, and perhaps you send information to the other party. Perhaps you don't make any final decisions at that moment, especially if you have a request to dismiss the due process complaint because the parent failed to appear. But whatever the case, you're trying to at least give the other party or the party that failed to appear an opportunity to be responsive, or at least to share the information that was shared with you with an opportunity to respond. And that may very well work, for example, with pro se parents especially, right? If you do have a transcript of it, right, you can always send the transcript forward to the party and allow that party at some point, depending on the circumstances that led to their failure to appear at the hearing, an opportunity to supplement the record. So there are many ways that we can address it, but what I'm hearing is that all of you would want to make sure that it's on the record. And although, yes, there's one person in front of you and the other party is not represented in front of you, that at least you want to have a recording of what was said so that the other individual has an opportunity to review that. Or if the fact that you had this one-on-one discussion with the other party is the subject of an appeal, that there is a record of what was said and that there was nothing that would at least violate the ethics rules or bring pause to anyone to say that you acted in a manner outside the scope of your responsibility as an impartial hearing officer. We did get another comment. Note that the internet has a tremendous amount of legal materials that are matters of public record, but not easily accessible to pro se parents or even sole practitioners. Think OSEP letters. Yes, those are very difficult to find, and that's why we put that outline together for you guys when we can. But also reported judicial decisions or the New York City SOPM, Standard Operating Procedures Manual. These hearings are meant to be accessible to parents without an attorney, and citation to web-based sources for materials that is otherwise citable should not be subjected to any special scrutiny. In short, legitimate legal research as opposed to fact gathering should not be medium specific. And John, this came from John Farrago, brings up a point that we're going to get to later in when we get to the technical rules of this. Let me just, are you seeing these, Lynn, or you're not seeing any other questions?
Not seeing any of them. I don't know what happened.
Oh, okay. All right. I'll just read through a couple of these and then I'm going to move on. Wikipedia has a lot of fake info, have personal experience with incorrect info on it, would never use it as a source, and that is a legitimate concern, and that's why I started with the decision of the Seventh Circuit and Posner, because most of us, if we hear Posner, we're like, well, that's a legit judge, man. We have a lot of respect for the guy, but he used it. However, he had an explanation for why he used it, as opposed, it wasn't a primary source for his decision. It was corroboration for his decision.
In the book, at least, he also says use it with caution. Wikipedia.
Yeah. And I think others would agree with that. I see a difference between the drug company's website and others. Citing the drug company website is like citing the evaluation instrument's publisher website on how to administer an instrument.
Can I say something about that, Dave?
Yeah, go ahead. Yeah.
Because my skepticism is that I have a nephew in marketing who works for WebMD, and although I've gone to WebMD myself, it gives me a certain pause in terms of relying on what they have to say. That's it.
So you're agreeing with the comment I said earlier, which is who's policing what I mean, these are marketing tools. They're not putting it out there just to say, hey, we want to give you the facts. They're marketing tools. They're selling their product. If a farm company doesn't conform to FDA regulations, if it will have consequences, yes, that's possible, just as if we don't conform our website as attorneys to the ethical rules of our jurisdiction, there may be consequences, but it comes back to the question of who's policing it. Sometimes it's easier to ask for forgiveness later after the fact. In my opinion, ex parte communications are those relating to the hearing or any issues relating to the hearing or hearing process, not such things as, for example, the weather. And we will talk about that. All right, I'm going to stop here because it's coming fast and furious, and I just want to move on a little bit. Doesn't mean that I'm going to ignore your comments or questions. We'll come back to it. So just quickly, because we paused for so many comments and questions, and please send them in. It's great. It makes it much more fun for me and for the panelists, and hopefully for you. Ex parte communication includes any communication between the judge and the party, or her attorney outside the presence of the other individual on a pending or impending matter. It also includes other communications made to the hearing officer outside the presence of any of the parties or their representatives. So let's just look quickly at the model code, the ABA model code. And, you know, I'm using the model code so that, in part because, as you know, as hearing officers, New York State hearing officers, there is not one set of ethical rules that apply to you as administrative law judges. There is a New York State administrative law judge ethical rules. There are the ethical rules that apply to all lawyers, but there's nothing in writing, anything in the New York statute, anything in the regulations that says this is what you're held to. You are not contractual hearing officers in the traditional sense that there is a contract that's provided to you each year, and within that contract you're held to certain standards. So I'm using the ABA model code here for purposes of our discussion, and most of what is in the model code, you will find snippets of it in the Code for Administrative Law Judges in New York State, as well as in the general ethics rules that apply to all of us who are licensed in New York State. The model code broadly defines ex parte communication to include independent research of facts. So the model code of 2.9 specifically says that ex parte communication includes the independent research of facts. Specifically, it says a judge shall not investigate facts in a matter independently and shall consider only the evidence presented and any facts that may be properly be judicially noticed. This language, if you look at the comments in the model code 2.9, extends to facts that are available through a variety of sources, not only those that are found in print, but also those that are found in the 130 trillion web pages across the web. With that, I'm going to pause there. I have code number 2 on the screen. Write code number 2 on your affirmation. While you're taking that down on your affirmation, I'm going to go back to some of the comments and questions and address some of those so no one feels left out. No hearing officer should be left behind. Also, the no-show, go ahead.
I wanted to go back and emphasize one thing with regard to the no-show. I think more than one member of the panel said that they would make an effort to contact the no-show party and or their attorney in an attempt to find out why they didn't show up. I just want to emphasize, I think, number one, that's very good practice to do that. But secondly, you ought to try and do that on the record. If you're calling somebody and you have the ability, given your setup, to have that call, both ends of that call be heard by the recording, do it so you have a record of your conversation should you actually be able to get a hold of them. And if that's not possible, at least put on the record what the call was made and what happened about the call, If there was a contact with another member of the family, what you found out about the situation, document all that on the record before you decide whether to proceed or not to proceed.
I don't think I've ever had a parent not appear when they were supposed to appear. I think this is just something that has happened with the district, which would would make it not as urgent a matter in terms of contacting them when they already know they should be there.
Well, I think it's wise to if they don't show up, I think it's wise to contact, because you at least ought to have an attempt to find out why that was. If they got into an accident, they got screwed up on the dates. I agree with you. Most parents are pretty conscientious in getting there. It's a big deal to them, and understandably so.
Well, outside New York City, everybody shows up because they have to show up. They're there in the district. New York City, there are many hearings going on, so we already see the people who aren't showing up. It's not like we're looking for them. All right, we already know they're there and they're not appearing because they're appearing in somebody else's forum. So I appreciate what you're saying, but it's not really possible to get them by phone in the same way. What are you pointing at, Day Steady?
We can't hear you.
Sorry, I muted myself while I was drinking, so you didn't hear me drinking. It's only an ice, right? It's only an ice, nothing in it. One of the questions that one of your colleagues posed is exactly the dialogue that you're both having right now. Why would I do that? And by that, he means you scheduled the hearing date, the party was unprofessional and failed to appear. Aren't there consequences to actions? And the answer is yes, there are consequences to actions. However, we cannot assume right off the bat, first time, that something may not have happened that prevented that party from participating. Perhaps one of your colleagues next door is saying, if you leave right now, I'm going to dismiss the case against you, or I'm going to hold the district accountable, and therefore you cannot go to IHO X's hearing room right now. There may be instances. That's not to say that you cannot, once you hear what the circumstances are, and perhaps after multiple warnings, or this is a repeat no-show, you can't dismiss. You may very well be, but you must establish a record to have a basis from which to make the informed decision that this is now the time to say, I'm cutting you off, no more chances. And there may be reasons that you just get one shot, but at least what I think we're suggesting in the dialogue we have, this little kind of offset of the dialogue, is that at least you make a record explaining or allowing the party to explain why there were no show. And if it's not a legitimate reason, then it's within your discretion as an independent hearing officer to move forward in how you think best.
Steady, I think there's another reason, and for me, it's an ethical reason. If I don't want, and actually what I'm about to say is, I think, consistent with the case law in our type of case, I don't want decisions to be made based on some procedural gotcha. Somebody messed up, they didn't show up. I want the decisions to be made based on the merits and the substance. So if somebody's not there, and there's a reason we have to go on, I'm going to do everything possible to pull the other party back in so we hear both sides.
And you have a legitimate reason, and I think that is consistent with what I'm saying. However, the hearing officer who raised the question has a legitimate reason too, right? If I do this multiple times and they just don't show up, what am I supposed to do? Am I supposed to just kind of drag it along and say, hey, when you decide to respect me and respect the system, show up? No, obviously there is a point where you can draw the line in the sand. However, how you get there to say this is it is as important as to when you get there and you'd say this is it.
I think putting it on the record, I think you're absolutely right. As long as you put it on the record what your reasons are, then the record speaks for it. Yeah.
Yep. let me just answer. And by the way, code number 2, if you walked away from the screen, it's up there. This is your chance to jot it down. I've kept it up for a long period of time there, so make sure you write it down. A party's failure to appear when a transcript of proceeding is made constitutes a waiver of a non-appearing party's right to object to discussions with the appearing party on the record. As to pre-hearing conferences where no record is made, the discussion and or decisions or outcome from the pre-hearing call should be documented to both parties. Okay, I'm gonna move on. Code number 2 is gone. All right. So remember, just kind of bringing you back, because I know we stopped for about 5 minutes there. The model code provides a judge shall not investigate facts in a matter independently and shall consider only the evidence presented and any facts that may properly be judicially noticed. So with that, what you should glean from that language is that not all research is prohibited. The legal research is permissible. The restriction is limited to facts. So judges can continue to conduct legal research beyond what is provided by the parties. That's simpler said than done, right? First, let's say what it's not, right? What are not considered, quote, facts or legal research that goes beyond what is permissible, of which we're going to be talking about in a few seconds. Past knowledge or experiences under Rule 2.9 is not considered research. Your own experiences, what you've learned in the past, is not considered, at least under the model rule, as research. Your participation in continuing legal education, like what we're doing right now, by attending programs, by reading legal journals, is not generally considered research. Now, it's a head scratcher, right? Because as we are going to talk about as we move forward, what's the distinction? And sometimes we come across information in a conference such as this one or a legal journal that can sway you, and it can include facts that are outcome determinative, and how that applies to your specific case can have an effect. So let's look at that right now. The first thing that we need to point out is that not all facts are considered equal. The rule supports, to borrow a phrase, alternative facts. The distinction between permissible and impermissible independent research turns on whether the facts included in the information being researched are classified as adjudicative facts versus legislative facts. And this is what I think one of the commenters referenced earlier during one of the other question and answer sessions we were having. Adjudicative facts are the facts of the particular case concerning the immediate parties. It's the facts about the case that's before you concerning the parties that are before you. What are those? The who, the what, the where, the when, the how. These are the facts that fall squarely on the parties to prove or disprove during the course of the hearing before you. There's no trespassing on these facts. You can't trespass on the who, the what, the where, the when, the how. Did I get those right? And any independent research of those facts, those adjudicative facts, is strictly prohibited by the rules, with one exception. There's always exceptions in law, right? And that is what we've been talking about. And those are the facts that meet the reliability requirement of judicial notice. And the parties are given an opportunity to be heard. And I think, Israel, you had addressed that earlier. Contrast the adjudicative facts with the legislative facts. Legislative facts, or what I'm calling alternative facts, do not concern the immediate parties. These are, quote, general facts. Their sole purpose is to inform you, help you, the judge, decide questions of law and policy, as well as allow you to have discretion regarding law and policy. These facts may be investigated by the judge on his or her own and are not subject to judicial notice. So you have adjudicated facts, the who, the what, the when, the where, and the how. Can't cross the line on those, with one exception. They're reliable, meeting the standard of judicial notice, and you provide the parties with notice. Legislative facts, you are permitted to do research, and they're not subject to the judicial notice requirement. Let's take an example for purposes of our discussion. And the example that I'm going to use is one that probably is going to bring nightmares to some of you back in law school. How many of you remember Plessy versus Ferguson? Oh, raise your hand. I could see you. I can't. Plessy versus Ferguson, the United States Supreme Court said what? That separate but equal schooling was acceptable because the equality of treatment is accorded when the races are provided with substantially equal facilities, even though these facilities are separate. That's what Plessy versus Ferguson decided. 56 years later, we get what? Brown v. Board of Education. And the United States Supreme Court faced a challenge to the separate but equal doctrine on the grounds that segregating public schools are not equal and cannot be made equal. In striking down Plessy, the court rejected, quote, whatever psychological knowledge at the time, end quote, at the time when Plessy was decided, citing to, quote, amply supported modern authority, end quote. Rather than cite to the record in support, the US Supreme Court did something differently. And in what? In a footnote. Remember the law professor saying, hey, read the footnotes? In a footnote. The court cited to articles that were written and available to the court at the time that they were deciding Brown, discussing the psychological effects of racial discrimination. Neither side had these articles during the trial, during the subsequent appeal to the circuit court, and were never afforded an opportunity to respond to these articles, let alone read these articles. How does that sit with you, panel? Setting aside for the moment, let's not get into the politics of that Brown v. Board was decided correctly. That's not what I'm asking you. How does it sit with you that the US Supreme Court cited two articles that were never part of the trial or the subsequent appeal to the circuit court, that they just cite to these articles that were available to them for purposes of overturning or at least supporting their ruling in Brown v. Board of Education?
Well,
Uh,
this is what Michael said before about Judge Posner, which is Judge Posner could get away with it. The Supreme Court was unanimous in this decision, so it got away with it. I don't think
Who do
it's
you
something
complain to?
we could do. Yeah,
Who do you complain
exactly.
to? Who can
Exactly.
Congress? That's all they can do, right? Change the law.
Judge, so I was once reading something about Judge Sotomayor, and she was criticized for this statement about when she was working in the Second Circuit. She said that the Second Circuit is a policy court, and she was criticized as a judicial activist. I think this was during her confirmation, but she's right. And the Supreme Court is even more of a policy court, obviously. And I think a court like that has that's what the country, that's what society wants a court like that to do, to give the ultimate answer on a question in the way they deem fit. And special ed connection or no, I don't think any hearing officer can go anywhere near what the Supreme Court does.
But Michael, that's so interesting because don't you think to some degree being an impartial hearing officer is like being a policy administrative law judge?
No, I don't. I think that we have the discretion to, if the law is close, I think we can do what we want and judge and decide on in favor of what is just. But I don't think that we're policy judges. I think I think it is balls and strikes as much as you can make it.
Getting back to Brown versus Board of Education, I think, well, most of us, or probably all of us would agree these days it was the right result at that time. In fact, people did criticize the Warren Court for being activist, and arguably they could have reached the same result while giving the parties a chance to respond to the research. And procedurally, I think that would have been better and less subject to criticism.
Yeah, I mean,
Judicial notice.
the bottom line is they drop a footnote. And while I understand we're not the Supreme Court, we're not Judge Posner, we're not a district court, we're not an administrative law judge at OH that wears a robe, right? But that said, if we believe in fairness, if we believe in making sure that the public has confidence in what we do, if the parties have a shot in hell to convince the court, shouldn't they be given an opportunity to review what they're going to rely on and respond to it before the court ultimately makes the decision? What's the point of the trial? What was the point of the appeal to the circuit court? If you are, at the district, at the trial, the judge made decisions as to what comes in and what doesn't come in, right? And they can only respond to that. At the appeal to the Court of Appeals, it's the record that was below them, right? They didn't get a chance to supplement. And if they did, the court decided that this is different. This is the Supreme Court saying, and yes, they got there and they earned it, right? This is the Supreme Court saying, oh, by the way, I read some extra stuff, and now everything that you've been arguing is discredited by these psychological articles, and that's what we're hanging our hat on. And we're going to throw it in a footnote because most of you don't read footnotes anyway.
Let me bring this home to special ed. Some of you are as close to as old as I was, and we had cases in the mid-'80s where ABA was in its infancy, and Lovas, it was called Lovas in those days, and to say that Lovas was extremely controversial. I had cases where I was given articles by Lovas, and then I was given counter articles about attacking Lovas's approach. Some of you may remember facilitated communication and how controversial that was. I had several cases on that with articles that were presented to me on both sides. And we have some interventions now that are controversial. Vision therapy is one that I know there are really strong differing views on its effectiveness. And so we can be thrust into exactly what the Supreme Court had in Brown versus Board of Education in terms of whether we're tempted. We may be given no articles, we may be given some articles, but we are certainly tempted in many of these methodology disputes, which are controversial, to potentially go and do, quote, independent research.
Well, actually, that's where I like to I sort of rely on my ignorance when it comes to things like that, which is that I expect the parties to argue this. And because no matter what I read in articles, I'm still not going to become really knowledgeable about it because these things are really outside my wheelhouse. So that I do want to hear testimony and perhaps experts or so-called experts on the subject.
Anybody else? Any reactions? Not hearing anyone. I'm going to continue. So allow me now, and then I'll take some other comments, which there are many. Don't worry, you will be given an opportunity to be heard. Allow me for the moment to discuss the overlap between Rule 2.9c of the Model Code, which governs ex parte communications, and Federal Rule of Evidence 201, which addresses judicial notice. And again, just simply for purposes, we know that the model rules obviously don't necessarily apply to you. The federal rules of evidence don't apply to you, but we do rely on them by way of analogy in order to have this discussion. And by the way, so I can give you ethics credit. So we have to look at these two. So let's look at the overlap between these two. Rule 2.9c allows the judge to consider facts that, quote, may be properly judicially noticed, right? So Rule 2.9c that governs ex parte communication says you can still, as a judge, consider facts that may be properly judicially noticed. Judicial notice, however, is defined by Federal Rule 201. Specifically, 201 permits a judge to take note of a fact that is not subject to reasonable dispute. Again, weasel words, right? Reasonable dispute, because it's a matter of common knowledge. Who's the standard bearer of common knowledge? That's up for you to decide. In most courts, they'll say you as the finder of fact. Or can be accurately and readily determined from sources whose accuracy cannot be reasonably questioned. So what's common knowledge? What are they talking about? Geographic locations. They're talking about periods of time. They're talking about historical events. What are facts capable of verification? Those include location of streets, distances, calendar dates. Only adjudicative facts. Remember, we have the adjudicative facts and then we have the legislative facts. The legislative facts, if it helps you remember it, alternative facts, right? Those are the ones that you can do research on. Those are the ones that judicial notice does not apply to. Only adjudicative facts, the who, the what, the when, and the where, and the how, and those are subject to judicial notice, and so long as you provide the parties with notice, are governed by Federal Rule 201. So Federal Rule 201, though, does not speak to legislative facts whatsoever. If notice is to be taken under Federal Rule 201, or is taken, as I said, a party has to be provided with the opportunity to be heard prior to the judge taking judicial notice, or after the notice has been taken. That or usually is something that you don't hear much about, because most people assume that judicial notice says, okay, I have to give you an opportunity to be heard ahead of time. But the rule actually says, Federal Rule 201 is either prior to taking it, or if you've taken it after the fact. Code number 3 is on the screen. So I'm going to put that there, and I'm going to take a break here to go through some of the comments that have come in. The code number 3 is on the screen. If you've walked away, come back. I have received an email from a pro se parent who did not CC the district's attorney. I deleted the email and wrote to both parties reminding them of the prohibition against ex parte communication. Good practice. Again, it doesn't always mitigate what's what the other party might say in terms of did you delete it? They have to accept your word for it. When I was an attorney, I actually got a letter from opposing counsel on a case I was litigating, and it was their settlement memo to their client. And I quickly, as this hearing officer did, called the attorney, asked him what he wanted me to do with it. Do you want me to put it back in the mail? Do you want me to shred it? You do whatever you need to do, as this hearing officer did, to mitigate those circumstances as best you can. My silence is my eyes are trying to focus on the little words on the screen. If a party got notice and did not show, and all statements go on the record, is that ex parte? Well, it's ex parte in that it's one-on-one, but you are in a position to mitigate any concerns that the other party might have regarding what was actually said and shared during the course of that discussion. My law firm's website has my legal opinions on laws, etc. Would be okay for someone to quote me. I don't understand the comment. I'm sorry. Is there actually an obligation on the IHO to try and contact anyone who does not appear for the hearing? Is there an obligation, a specific rule that says you must do this? I've not seen one in New York State. However, is it best practice to try to define what, or at least determine what happened, especially if you're taking some steps to cut the right of that party off? Absolutely. I think that just general principles of due process would require that. And anything, a dismissal is considered a sanction. And what I will tell you, and if you remember, we did discuss many years ago, some of you would have had it, may not have been part of the training, but I would have provided it to you in your training manual for new hearing officers, the sanctioning authority of hearing officers. And what I posit in that discussion is that before you can take a sanction, and a dismissal can be considered a sanction depending on the circumstances, that you do whatever you need to do in order to mitigate the ultimate penalty, which is, for example, in the case that I'm talking, dismissal, and that you take baby steps. So it would seem to me that you will not, in terms of the standard on appeal, whether you were arbitrary and capricious, that a court would look at what did you do to mitigate some of this? If you just dismiss because the party did not show up, and it turns out that the party got into an accident, ended up on an ambulance and went to the hospital, and they can show that to a judge on appeal, that judge may very well likely reverse your decision. I thought I just saw some ghosts pass me by. They shouldn't, you say that our colleagues shouldn't do that? Sorry, that probably came right after I said something, and I don't remember what I said, so I'm sorry I can't respond to that. This is really just typical to New York City. They very frequently do not show up for hearings or pendency. I put it on the record, but it's so frequent that at this point we know they know, but they have 3 hearings scheduled at the same time and they choose where to go. Yeah, I mean, you're right there. And again, there is a disconnect between some of the best practices, standard legal practice that we talk about, and then there's the reality. And there's the reality of the world, meaning anything outside of New York City. When you come to New York City, you sometimes have to accept that it's just so different, perhaps a parallel universe than what happens everywhere else. And I accept that, and we do our best to mitigate against it, but there's not much we can do given what happens in New York City, especially under the strains and stressors that that New York City is facing right now, and you are facing as a hearing officer. Authorities learned about in a context such as this, or almost any other, that are legitimate forms of citable authority should not matter how you stumbled across them. They are the fruits of legal research. Okay? Note that in Brown, the question was whether the lower court had adequate foundation for its factual determination that separate but equal had psychological impact on students. That's a different appellate context speaking to proper standard for review of a fact finder's determination. Understood, but again, that doesn't take away that the parties were never given an opportunity to respond to these articles that the court accepted as being correct and accurate. No one ever challenged the validity of the science, the empirical data that was relied on it. At least the parties were not given that opportunity. The court accepted it as being valid. What would the difference be in the Supreme Court if the Supreme Court had cited to a case that no one else cited? I guess it depends what they cited the decision for. If they're citing it for legal precedence, I think there's no problem with that. And in fact, it's incumbent upon the parties to present decisions to the courts, whether they're favorable or unfavorable to them. So I don't think that's the issue. The question is, if they cited to and accepted the facts of another case as being true, without really allowing the parties an opportunity to wrestle whether there is a distinction between the facts of that other case with the facts in this case, I think that starts to become a little dicey. Doesn't mean that it's wrong, it just becomes a little dicey, and this distinction that the model rules and the federal rules of evidence tries to make is not as distinct, is not as clear as they like it to be. Further note that, in fact, the court had submitted to it an appellant's brief subject to review and response by the appellees, a social science statement as an appendix which summarized the alleged psychological and sociological foundation for the district's court findings. Yes, and that may have happened, and I don't have all of the historical data here, but again, what it's clear is that the specific treatises, the specific scientific evidence that they relied on was not in the lower courts and the parties did not have an opportunity to respond. When I receive an ex parte communication by email, I immediately forward it to the party who is not included in the communication. And that is best practice. And one extra step after that is, well, so what? What do we do with it now, right? Just because you disclosed it doesn't necessarily mean we don't have to address it. It depends on what that, quote, ex parte communication is. Perhaps you got it could be ex parte because they sent it to you, but you weren't the intended audience, the example I gave, right? It could have been a settlement offer to the other side, or it could be say, we absolutely blew it, you're absolutely right, however, we're not going to give you 100%, we'll give you 50%, or we go to hearing. Well, if you see that, you can't unsee it, right? So how do we address that? And that's a legitimate question to ask. I think I've covered all the comments and questions. Code number 3 that's on your screen is now bye-bye. Let's move on. Because I want to get to some of these hypotheticals. So, So judicial notice, as I was referring, the distinction between legislative and what are my other facts? Help me out, people. It's late.
Adjudicated?
Thank you. Adjudicative facts does not cure the real risks in allowing independent research, especially in light of legislative facts and I highlighted some of that. So what then? What are our options? Given this blurred line between adjudicative and legislative facts, one easy answer might be don't do any research, right? And there are many pros, many reasons for not doing any research. Let's talk about some of those. One is that the process is party driven. And by that I mean, it's the burden is on the parties to give you what you need and what is required of you in order for you to make and render an informed decision. Makes sense, right? It's your job. I think Michael used the words that we've often used. You're calling balls and strike. You give it to me, I call the balls and strikes, and that's all I want. I'm only going to decide my decision based on the four corners of the record. A second pro for not doing any research is it maintains your actual and apparent neutrality, right? If we want the system to be believable, if we want the system's integrity never to be questioned, then let's not go beyond what's in front of me and what has been presented to me. Another pro is it keeps you from coming into contact with information that is unreliable. It can be disputed. Think Wikipedia, which permits, as we discussed, anonymous and collaborative editing by anyone who has access to the internet. Once seen, you cannot unsee it. Another pro of not doing any research whatsoever is that it eliminates the real human tendency to gravitate towards information that confirms our pre-existing beliefs and our biases. And now we're doing that subconsciously, right? If we have an idea of what we're looking for, we're not plugging for, find me neutral information about this. We're plugging the limited information that we have that might get you to a specific website that confirms what you believe, leaving out, because of the search terms that you put in, others that may that may give you a different perspective, a different view. Another pro of doing no research is it keeps us from interpreting information that exceeds our knowledge base. This is, I think Nancy referred to this, it's above our pay grade. And what do I mean by that? Well, if I go to the Mayo Clinic, if I go to, what was it, WebMD, I think you referred to, Nancy, if I go there, or if I come across a scholarly medical article, I am reading this with my layperson, my lawyer's hat. I may not fully appreciate what is being said in that article, and I may be making assumptions about what I actually understand, and then I'm applying that to the facts in my case. That could be problematic. There's no one there to challenge you. There's no one there to say, no, I get why you see it that way, but that's not really what is happening here because of XYZ reasons. And finally, it promotes, right? Why would we stop doing research? It promotes transparency because the basis for the decision is limited to the record. Now, having said that, I gave you 6, 7 reasons why no research might be the better way to go, right? It keeps us out of trouble. Nice, but not practical, not sensible. And as Judge Posner suggested in the case that I referred to, the inmate and the Santac, there is the danger that in deciding these cases between these parties, that the parties, as in the inmate versus the prison officials, they're not on equal footing. And one of your hearing officers talked about access to information. Not everyone has access to information. Not everyone. I've worked in jurisdictions, and there still may be places in New York City. I know there's schools out there that have not gone to Wi-Fi, et cetera, and still use facsimile machines, et cetera, that don't have access to the internet. And there's a huge concern there that that the parties are not in equal footing. And the courts have said that to us, right? The United States Supreme Court in Schaefer v. Wiest talks about the fact that the district may have additional information. They have the expertise. They have all this other information available to them, and they talk about perhaps the parent has that information. But time and again, if you look under IDEA cases, we are reminded that the parent is not necessarily always in equal footing with the school district. And in fact, many of your cases, many of your interim orders talk about the parents trying to access information that they need in order to present their case. They want to subpoena documents. They want to subpoena witnesses. They want those emails, right? So we have to accept that perhaps the parties are not always in equal footing, and that some level of research may be necessary. How we do it is the crux of the question. So what am I? Yeah, go ahead.
I could just jump in. I think another reason to do the research, besides the fact the parties are not on equal footing necessarily, is that it gets to the issue of what is our role as a hearing officer or as a judge. Are we just referees or baseball umpires, or is our job to get it right? And I've seen lawyers who you would think know what they're doing, and generally they do know what they're doing. I've seen lawyers, we're all human, cite a case that's been overturned. Now, we're supposed to come up with decisions that are legally correct and are just. And so I think part of what we need to do is, we can't just rely I think Judge Posner looks at it that way, and many other judges. You can't just rely on what people tell you. We have to end up with the right result, the correct result, even if the lawyers mess it up.
Well, I don't think this is only about research, though. I mean, I think some of this is that as impartial hearing officers, we shouldn't just be waiting for what's presented to us. We should, in fact, if there's missing information and the parties are not equally balanced, we should be directing that we want further information, or we want a witness to address something. For example, I'm always asking these days about what the costs are of services, all right? And that's not always presented by either parent or challenged by the district, but it's something I want to know. And I ask the parties to present that evidence. So it's not only about just internet research. I think it's also about outside the scope of what's being presented to us and what we can ask for or demand.
You both bring some interesting, valid points, and I think you've heard me say before, you've heard Lynn say before, you've heard others say before that the purpose of IDEA is to make sure that the rights of the child and the parent are upheld. And it doesn't say that obligation only falls on the parent and the child. It applies equally to the school district. It applies equally to you as a hearing officer. How you go about it is where you could get into trouble depending on what you're required to do. And my outline that is on the control panel on developing the record gives you some ways to do it that keeps you in the straight and narrow. Now, I recognize that there isn't a right or wrong answer to this question as to, do I go after completing the record. And I recognize, having talked to many colleagues, not only in New York State, but across the country, administrative law judges, here, contractual hearing officers, a hybrid of the two, that there are some who believe that, yeah, my job should be more to call balls and strikes. And some of them qualify it when I have competent lawyers before me. And that may be true. But even when they don't have competent lawyers, some will say, my job is to call balls and strikes. I think I'm crossing the line. And I don't take that away from that. I think this is a larger discussion that we'll have to have another day, because I need to move on, because I do want to get to some of the hypotheticals. But there is a discussion to be had when we're talking about developing the record, managing the hearing, about how we see our role in the process. And for some of us, others will consider you active judges, active hearing officers. Others will just be happy just sitting back and saying, I'm going to call balls and strikes. And there isn't a wrong answer to this. There's nothing that says that you have to complete the record. Although in New York State, I do point out that there is a regulation that says that you, as a hearing officer, have the authority not only to ask questions for clarification, but also to complete the record. With that, let me just talk about the middle ground that I think would keep us out of trouble. I don't think that not doing any research altogether is necessarily the answer for the reasons I stated earlier, which is that there is the concern of making sure that the parties are in equal footing to have at least the opportunity to present you information that allows you to make an informed decision. So the first thing that I would suggest is that we adopt best practices to completing and developing the record. That's the document that's on the control panel, and it's referred to on footnote 54 of your ethics outline. Second, if we are going to do any research, then let's borrow what we already know from Rules 2.9 and Federal Rule of Evidence 201, right? And that is that it should be incumbent upon us to disclose any research that goes beyond pure legal research. And we should afford the parties an opportunity to challenge whatever information we uncover prior to adopting any findings based on said research. If we're going to go out and do it, then, give the parties an opportunity to respond. Give the parties an opportunity to educate you as to why whatever you determine or whatever you found is in fact something that's reliable, relevant, and doesn't require any additional testimony on behalf of another witness on behalf of the party. And finally, give the parties an opportunity, as I just suggested, to supplement the record and, if necessary and appropriate, to address any new information. Now, I recognize that while I'm saying that there is the reality of a timeline, right? IDA works on a timeline. So when you're thinking about this, keep that in mind, which is if I get my hands on this additional information, can I get back to the parties on time to give them time to react? So that's always a consideration in the back of your mind, and no IDA training would not be complete if I'm not reminding you of the timelines, right? Shoot me, right? I'm always talking about timelines. So with that, I like to take an opportunity to talk about to do some hypotheticals. But before I get to the hypotheticals, I do want to put up code number 4 there, and I'm asking you to write down code number 4 on your affirmation. I'm going to go over a couple of questions and answers just to leave that up there for a little bit, but I'm going to move on fairly quickly so that at least we get some hypotheticals. I want to see if I can engage the rest of you out there in cyberspace. So allow me to read a couple of comments and questions. After I receive a DPC and I have never heard of the disability listed on the treatment being proposed, I will often Google it. Where is the line between not investigating facts and being an informed IHO? Are we being too narrow? If there's information out there that could help the student, shouldn't the LEA be aware of it? I had a legal professor who advocated for citing to publish articles. I think you raise an interesting question, right? If I am just generally getting myself up to speed on something, knowing that I am open to being persuaded otherwise, or someone filling in the blanks, is it wrong of me? Some of the hypotheticals are going to address that, so we're going to look at that as well. But you raised a legitimate, is it bad? If I'm just getting general information, just as I got general information in tonight's webinar, just as I get general information when I go to a PLI conference, or I go to any other conference that talks about disabilities, LRP, the Academy of Administrative Law Judges and Hearing Officers, I got information. I said earlier that that's not considered outside the scope. That's permissible research, right? So it would seem to me that your example may fall in the permissible research, depending on how you move forward with that piece of information. With that, let's start with the hypotheticals. Code number 4, we're moving on. So here we go. And let me see if my polling starts. I'm going to start with reading some of the hypothetical. You have it in place, or at least in hard copy, but I will read it for purposes of our discussion. So give me 1 second. I need to hide my webcam because it's blocking my screens. Give me 1 second. People can see me. It's telling me people still can see you even though it's hidden. I know you can see me. All right. Administrative Law Judge Wendell Holmes, ALJ Wendell Holmes. By the way, you're administrative law judges. You don't have the title. You have the same authority as any administrative law judge that sits on a central panel in any other state under IDEA. ALJ Wendell Holmes is assigned to a due process hearing. ALJ Holmes was quite familiar with the bar, both on the school district and parent side. However, in the last assignment, the parent was being represented by an attorney who was unfamiliar to ALJ Holmes. Though the complaint left a lot to be desired, ALJ Holmes did not put too much thought into it until he found himself in what he described as a, quote, tortured pre-hearing conference. The attorney evidenced a poor understanding of the IDEA. As soon as he concluded the call, he was plugging the parent's attorney's name into Google. As he scrolled through the results, he learned that the attorney had practiced in a neighboring state, but had been disciplined for failure to provide competent or responsible representation to his clients. The attorney maintained his license. Is that permissible research on behalf of ALJ Holmes? So you have a quick poll there. Yes or no?
The poll doesn't work for us, does it?
No, I don't think it works for you. I think it's grayed out.
I tried.
Yeah,
I
sorry.
tried this one.
Yeah, I don't think it works for the panelists. We tried it earlier today. I'm hoping it works for the other folks. I think it is because I'm getting answers to it. So just a few more seconds, because I do want to cover a couple of I have more hypotheticals than we're going to cover today, but I just wanted to have them there in case we did not we went through the information quickly because we didn't have the wonderful discussion we had. All right, so with that, I'm going to close the poll, and then I'm going to share the results. There's a little lag on this. 59% of you say that yes, that the research was permissible, and 41% said no. So my esteemed panel, do you want to react to some of that?
Sure, I think it's permissible. I mean, we get all kinds of incompetent attorneys in front of us, or at least attorneys who don't always know what they're doing. And I think it's permissible to look it up. That's not the same thing as the answer to the second part.
Yeah, do you have a responsibility to disclose? Do you want to tackle that?
Oh, yeah, I would say absolutely not. Absolutely
Okay.
not. I mean, our responsibility goes back to what Israel and I had been discussing before, which is if there's somebody incompetent in front of us, what can we do to make sure that we get a complete record that is accurate in terms of what the child is entitled to?
So for purposes of, or at least saving time, Michael, Israel, do you have a different answer than Nancy offered?
No, I agree with Nancy. This doesn't, this is part of our responsibility to understand what's before us in terms of the attorneys, if they're competent or not, but I don't see a problem. It doesn't bias the case.
Well, let's talk about that, right? To some extent, it doesn't can it have the potential to bias the case if the information you have a lawyer who's been deemed or who was disciplined for failure to provide competent and responsible representation. What I hear you saying is, yeah, that's information, but that information on its own we need to put it away somewhere, and we shouldn't use that to the detriment of this lawyer's client, and that we may have to do certain things during the course of the hearing to at least mitigate these failures. And perhaps it's just being clearer with the lawyer, perhaps putting in writing what your expectations are on certain things. But generally, what I hear is no concern here. We're good. Not an ethical violation so far. Not impermissible research. Let's move to the next one. So we have, while writing his decision on the tuition reimbursement case, IHO Louis Brandeis curiosity got the best of him, and he visited the school website and quickly flipped through its pages. He marveled at the beautiful architecture of the school buildings and then returned to writing his decisions. Any concerns with that? Any concerns with that, panel?
Oh, this isn't a poll.
No, I'm not polling that one yet.
Am I on? It seems, to me, it's not, I don't think there was any reason to do that, because it's kind of, it's almost like, I once had a parent at a hearing tell me, why don't you come visit the school and see it for yourself? Even though here you're looking at the website, why is this being done at this point? It sounds like the party should be allowed to make their case. Now, I myself, as I mentioned earlier, once went to the DOE site to check on how a program is defined, but I don't see why at this point in the why you need to be looking at the website and flipping through its pages.
Obviously, the testimony during the course of the hearing talked about rolling hills. I had a case there where that was the defense, that basically the parent wanted to send the kid to a nice little campus with rolling hills, etc. What if he visited the website to confirm what he gleaned from the record regarding the general program? Does this start to become a little more?
Well, if he had a reason to do it to really understand the evidence better, then I would take judicial notice and let the parties know I either before or after this, so they have an opportunity to respond to it, because you might get the wrong impression from something you see on the site. Maybe they have.
I think it's a question of whether it's dispositive or not. I mean, it goes to your last question here, which is if the ALJ decides to change his answer based on what he sees on the website, that would be truly improper.
So let me read that one, because this is a poll and I want to get the others involved. It's okay, he's looking. That's okay. No, that's all right. So during the course of the hearing, now the party raised a concern about the kid's disability category. But while he was satisfying his curiosity and looking and marveling at the architecture, he learns that the school serves only children on the autism spectrum with an autism spectrum disorder. The student in the hearing has been classified as learning disabled, and the parties agreed that that's not in dispute. However, because of what Justice Brandeis, or hearing officer Brandeis, learned regarding that it only serves ASD kids, he denies the reimbursement because we have a learning disabled child. And so my question to you is, just to get a sense from the others, is it proper? Is that proper research?
Well, is the question whether it's proper research, or is the question whether the use of it is proper?
Both.
Okay.
Now, the problem with polls is that we don't get to engage the rest of you, and I'm sorry about that, but I thought that at least we get to hear you and your thoughts. So I'm going to close the poll now, and then I'm going to share the results. Interestingly, 84% of you say, no, you went a little too far, Brandeis, but 60% of you say it's okay. It's okay. Unfortunately, I can't engage you on that. But it starts to bother you that here it is. It's not even in dispute, the disability category, right? It's not even in dispute. And here Justice Brandeis, or IHO Brandeis, decided to flip his reimbursement award and deny it because the school did not serve. Wouldn't there be shouldn't there be an opportunity to ask the parties why this LD child would be properly or functionally grouped in this group of ASD kids? It's a question to that the parties may have a valid answer for the hearing officer. Let's move on. Hypothetical number 3. We got now William Brennan. He's presiding over a hearing in which the parent sought through her attorney that the school district be required to directly fund a private placement for her child. In my old days, they used to be called Connors cases. I don't know whether you continue to call those Connors cases. The parent sought direct funding because she claimed through her attorney that she's unable to pay the private school's tuition as she's financially strapped for cash. The student remains in the public school. In drafting his decision in favor of the parent, which included an order that the district pay the school the tuition directly to the private school, Brandeis comes across, as he's confirming some other things and finalizing the decision, he comes across an email that came from the parent that came from the parent's work email address, and he sees that the parent works in a prestigious law firm in the city. He then, curious as we all would be, Googled the firm and finds out that the parent, in fact, is the managing partner of the firm's mergers and acquisition division and has a long list of wins under her belt. Feeling duped, hearing officer Brennan changes his order to say that the school district is to reimburse the parent for tuition costs upon submission of adequate proof of payment by the parent to the private school. So, any concerns with hearing officer Brennan's flip-flopping? All right, I'm going to close the poll since it kind of died down. 64% of you voted. I know everything. 64% of you voted. 59% of you believe that Brennan's flip-flopping was not proper. But 41% of you, a little closer, believe that it was proper. Any of the panelists have anything to say about that?
Well,
Yes,
I want to say something, which
go
is that it says here that it was claimed through her attorney. So the question is, how can you be duped if the person didn't themselves testify? I mean, you need evidence from the person concerning their money, not just a claim through their attorney. And the other part is, yeah, I would be that the flip-flop is improper, unless they get the parties back to talk about it.
Okay.
That second part is what I wanted to emphasize. It sure looks like they were trying to pull something. However, who knows what the explanation is? If I came across something like that, I should give the parties a chance to respond, and they may back off in that request, frankly. And then, but to make a ruling that based on some discovery that they can't, factual discovery that they can't even respond to, has a certain element of unfairness to it.
Yeah, just to say a person can afford $100,000 a year without any further information doesn't seem fair.
But,
No matter
hearing Officer Brennan is way out of line for Googling the firm. That's judicial misconduct as far as I'm concerned. Hearing officers have got to be crazy to start Googling the firm and then making a decision based on that. Why do it? To me, you're just asking for trouble, and it's better to be safe if you're deciding a case as a hearing officer.
Can I just say one other thing? I think it was Israel who mentioned at the beginning, about Judge Posner's book. But I went to a conference, a State Bar Association program on social media ethics last year sometime. And in fact, the State Bar Association has some guidelines posted, from whatever the section is on social media, concerning, ethics involved in what you're looking at, communications among attorneys concerning social media research, but also communications with judicial officers in case people are interested. That's all.
Thank you. I'll share a little anecdote of a rookie mistake I did when I was litigating one of the Connors cases. I never asked my parent how much money they made, and I presume the sob story, etc. And I didn't even get my fee up front. It would be coming up in bits and pieces. And something struck me during the course of the hearing, as we're going to get into this testimony, to ask the parent, well, just tell me how much the money you make. And it was something close to about $750,000. My jaw dropped. And I stopped the hearing at that point, pulled the parent out, said, can you write that number down on the piece of paper because I can't process it. And we ended up, concluding that case at that moment to come back. And I spoke to the parent about that I couldn't put before this hearing office in good faith that the parent was destitute, making, a gross salary of $750. And the parent says, well, but I have a huge mortgage. I'm like, I get it. That's not what this was intended for. So my rookie mistake, but it's that's where this hypothetical, by the way, came out. Let me do one more before we conclude for the day. Here we got Judge Marshall, who lives in a small town. He doesn't have children in the town, so he has no problems taking cases from the town that he lives in. And he took one such case, and the parents sued the school district seeking a costly program for severely disabled child. At the hearing, the school district argued that the program was too restrictive, and that the school could meet the kids' needs in town. The parents parent argued that the IP was predetermined, and it was predetermined because the school district was facing budgetary constraints, and therefore they couldn't raise the taxes to cover the cost of special ed, and they were not going to put this kid in there because of the budgetary constraints, not because of his needs. And the parent recounted a testimony in a discussion with the director of special ed that at the IP meeting, the special ed director says, you know, we are having a hard time paying our bills. We work with me, and I promise you I'll do the best I can and provide you with what I can offer to your child. The hearing officer was impressed with the parent and thought that the parent was generally credible, but that aspect of the testimony was a little flimsy and lacked corroboration, so he did not credit it as the parent would have liked. However, before the case ends, one Sunday morning, they're reading the local Times Union or whatever else you want to call it, and he comes across an article in the town's newspaper that says that this district is in fact facing financial difficulties, and that the Board of Education voted to cut programs in order to stay within budget and be able to pay for potential special education liabilities that are looming. Does hearing officer Marshall have an obligation to disclose that he read the article, which corroborates the parent's testimony? So I'm going to open that last poll up. Give me 1 second, and then while that is coming in, I'm going to ask my panel to react to the obligation of hearing officer Marshall to disclose that he read an article that substantiates the parent's testimony. The case hasn't closed yet.
I think I'd be giving one opinion of the two you're asking people to vote on, but I think he should disclose it because this is, talk about hearsay. This is very important information that you're accepting for its truth, and who knows? Newspapers don't always get it right, and let them have a chance to react to it. They should be disclosed.
61% of your colleagues who voted agree, 39 do not. Michael, you wanted to say something?
I mean, of course he should disclose. I mean, anyone who is litigating the case on either side would want, especially for the adverse side, would want him to disclose. I think a question is, how many people have the integrity to disclose in that situation, frankly? But you absolutely should, and maybe even recuse in a situation like that.
Well, thank you. I just want to mention 1 second, Nancy. Let me just say code number 5 for you folks. It's 8 o'clock. It's on the screen. Please write that down. Nancy, you got the last word there.
No, I was just going to say, I never trust articles anyway. Whenever you read an article in the Times about the education system in New York City, you can understand, why maybe you shouldn't believe what's in articles on all subjects. That's it.
Okay, thank you, folks. It's 8 o'clock now. Code number 5 is still up there. I want to thank our panelists, Nancy, Michael, Israel, Lynn. Thank you so much. I hope that for those folks out there, you found this at least engaging, and I'm glad that we were able this time to provide you with some ethics credits. I know things are not where it needs to be for everyone, and I hope that at least these 2 ethics credits would be helpful to you. I appreciate your time this evening, and we look forward to meeting again in March for our second webinar of the year. Thank you, folks, and good night.
Thank you, Day Steady.
Thank you, Nancy.